Hey everybody, my name is Jeff Lee. I'm a certified criminal trial specialist practicing in Memphis, Tennessee. I want to talk to you about what you saw on the news tonight. Maybe you were watching the highlights from the Derek Chauvin trial and you saw that today he made the decision not to testify. In fact, he told his attorney that he was pleading the fifth. What does that exactly mean when somebody pleads the fifth? Who makes that decision? And was the jury able to see that strange exchange between him and his defense attorney where they were sitting at the chairs together? Stick around and we'll talk about it in 2 seconds. It's probably been a while since your high school civics class, but you may recall that the Fifth Amendment to the United States Constitution contains, among other provisions, a provision about self-incrimination. A defendant does not have to testify against himself or herself in a criminal trial. So what does that mean? It means that you can't just get up and say the part that you want to say with your attorney on direct examination, and then when the other attorney comes up and says, well, I got a piece of paper here, I want to ask you cross-examination questions. No, I don't want to answer those. You can't just get in the good without putting in the bad. You have to be subject to cross-examination. And if you think that that cross-examination is going to get into some territory that you don't want to go into, you just decide, I'm not going to testify at all. I ain't getting up there. If you were watching, you saw that the defense attorney and Derek Chauvin were sitting at the chairs together. They weren't up in the witness stand, they were at the defense table. Now that was probably unusual, you've probably never seen that before. Well, even if you have been a juror in a trial, this is a hearing that happens outside of the jury's presence. In the state of Tennessee, we call it a moment hearing based on a case precedent. And it's important that the defense attorney asks questions to the defendant, not the court. For example, if I were the defense attorney, I might ask questions like, who made the decision whether or not to testify? Were you given anything in exchange for that decision? Did anybody try to compel you or make you testify? Who made the ultimate decision to testify or not? Now, did I, as your attorney, give you all of the information that you needed to make that decision? Was there anything else that you needed before you could knowingly, voluntarily, intelligently make that decision? And if the person says, I've had all the information I need, I'm the one making the decision, and I do or I don't want to testify, then the court is satisfied. Why does the court do this? To be honest, they do it to close any avenues for criminal appeals. Now, of course, if a person loses, they still get a criminal appeal. But one of the issues that the court does not want to have to face down the road is that a criminal defendant says, hey man, I wanted to testify. My attorney would not let me get up on the stand. And that's not his decision, that's my decision, and he wouldn't let me do it. Who knows what happens in the closed rooms with attorneys and defendants. And that's an argument a person might want to make if they're facing a long jail sentence. But when that person gets into the courtroom and says, no, I'm making the decision, now they can't argue that later. The converse is true as well. A person could say, I didn't want to get on the stand, and my attorney made me get up there, and I didn't even know he was going to call my name, and he said, next witness, you. And I got up there and I did a terrible job. I told my attorney I didn't want to get up there. Well, in the same way, during that moment hearing, if the defendant says, I don't want to testify and I'm making that decision, or I do want to testify and I'm making that decision, the door is closed later to try and make that argument. I want to remind you that the jury was not in the room to see that exchange. I know it seemed almost informal, that they were kind of sitting right in each other's faces and had a microphone. Derek Chauvin did not get up in the witness chair. Well, that's because it's sort of a less formal hearing. It's really building a record for the court reporter. It wasn't the kind of thing that you'd see when you put experts on the stand and stuff like that. But in case you had any questions about that, Put them down in the chat. Let me know what questions you have. Are there other things about the Fifth Amendment that you'd like to know? Let me know. Thank you.